Okay, I'm gonna plow ahead. Um, our next, sorry. Our next panel was the other, excuse that. Our next panel was about other states. So this is where I get to say that my dog was trained in prison and he was obviously released early. Apologies. All right. So our next panel was about what's going on in other states, sentencing practices in other states, and particularly some discussion about determinate versus indeterminate sentencing schemes. In my mind, two states and two of the presenters really stood out. The first that was very intriguing to me, and this is a wholesale difference from California's system, is the Utah model. The Utah model, just to summarize, is where defendants get an indeterminate sentence of, I forget the particular range, but let's say 5 to 10 years, and then there is a sentencing guideline, or maybe it's better to say a parole guideline that says that given this person's criminal history and the particular crime that they've committed, that parole will be, strong presumption will be granted after 7 years, let's say. So the judge imposes the sentence of 5 to 10 years. Then the parole board implements the guideline range of, in my hypothetical, of 7 years, with a strong presumption that 7 years is the actual sentence. Of course, based on prison behavior, that could be extended. I don't know if it could be shortened, but that's the way the system works. And the advantage that I see there, again, putting aside the practicalities of implementing that in California, is, of course, what I've always seen as a big problem is how do judges on the date of conviction or close to the date of conviction say 10 years is the appropriate sentence or 5 years is the appropriate sentence? How will I know? How does one know that within X amount of time that person will have sufficient removal from society, rehabilitation, growth, all the things that we hope to happen in prison? Whereas that decision seems more appropriate, decided on the back end, which is the Utah model, again, but using the guidelines so that everybody at the date of conviction say the presumption amount of time that you will spend behind bars is 7 years, but that is based on your assumption of good behavior. So anyway, I was just curious if people had reactions to that plan.
So how is that different than, the conviction comes in and you set it for, sentencing in 30 days and you get a full report from the probation department, and the probation department will make a recommendation as to low, mid, or high term.
So the difference is that the determination is made at year 7.
At year 7.
At year 7, the parole board, or the Board of Pardons, I forget what the name of the organization is called, says, okay, that was the presumptive the presumptive sentence was year 7, but really you haven't completed your programming, you remain a danger to public safety, and so we're going to, you have up to your statutory max, which in my hypothetical is again 10 years, but you're not prepared for release. Tom, am I summarizing things appropriately?
I think so. I think the ranges are bigger than that, but yeah, I think that is a good way of looking at it. And I will also say that it's very much what California did before determinate sentencing, where the judge basically picked jail, probation, prison, and if it was prison, the parole board here also had total discretion, essentially, when to let people out. So it's
Yeah.
sort of a time traveler situation a little bit.
So does the judge actually sentence at a sentencing hearing? I mean, how does that work?
I think so. I think I'm trying to find my notes where I had the ranges. There's basically it's just very different. It's just you decide on, you know, what it's those choices: prison, probation, or jail. And if it's prison, the judge doesn't have much,
Right.
doesn't set the max or the minimum.
Yeah.
I mean, I think we also need to, you know, something that I need to remind myself every time we think about these types of issues is that 95% of cases, judges aren't really doing the sentencing anyway, right? They're plea bargains.
Yeah.
So, you know, the role that the judges do sentencing is you know,
That's a trial.
is in the vast majority of cases not the case.
Yeah.
Yeah, I mean, that's my question is how would a system like that impact the way we currently process and resolve cases through plea bargain?
Well, I asked that question of the guy from Utah, and he said, you plea bargain and you say the presumptive sentence is 7 years, again, using my hypothetical. We all agree that that's the presumptive sentence and you're going to plead to that.
Yeah.
Now, whether or not that actually is a sentence, everybody appreciates that. And in the same way that is in California, that everybody appreciates is good time credits and other ways that, you know, may adjust somebody's sentence. It's a little bit more transparent, I think. It makes sense to me in that the decision is made at the back end rather than the front end. I suppose that without completely upending California's system, getting back to our previous conversation about Prop 57, is that you could build in guidelines to, rather than just being this paper review, that's just, your base term was 5 years and you have 30 years of enhancements, right? And the paper review is, the only question is, are you a danger to public safety? Perhaps there could be guidelines put into that to say for X amount of person, there's a strong presumption of release after X amount of years. Perhaps even in any event.
Yeah, I think the difference in Utah is just the fact that in the end, it's the parole board that decides everything. And so you can agree, the defense and the prosecution can agree to a guideline term, but in the end, they know that it will be up to the parole board, whether or not they actually get out on that date or earlier or later. And I think Mr. Thompson yesterday was saying sometimes they'll agree, and then when that date comes up, the prosecution will call the parole board and say, hey, actually, we didn't really like that date. Maybe you should extend that out. And that was the problem that they were dealing with in their system when, they came to a conclusion because they were trying to get a deal settled, but the prosecution didn't really like that deal.
You'd have to have some precautions, some guidelines around ex parte communications between the decision maker and prosecutor.
Right. And there's just so much power in the hands of the parole board and who those people are too. I mean, that makes a huge difference in that system.
My mind is that this is a very interesting and on paper, probably preferable system. Whether or not it's practical in California, it just seems kind of overwhelming, and giving all the concerns that have been discussed already about the parole board to give even more authority over all sentences seems daunting. But in my mind, I would consider folding some sort of idea like this into the Prop 57 discussion that we had a moment ago, where the parole board is already reviewing sentences early, but again, without guidelines, without presumptions, without statutory direction. So that would be sort of my inclination on this point. I don't know if others have thoughts.
I have two pieces of information that might be helpful. First, the prison population in Utah is, I think, less than 6,000 people, so it's just a much smaller system. I think it's important for us to, you hinted at it, Mike, but it's the scope of our system is just, I think it actually might literally be exponentially bigger. I'm not sure. And then Judge Espinoza, I guess this will earn me some nerd credentials, but I actually have the guilty plea rate from the indeterminate sentencing years in the 70s. And I think overall there were less guilty pleas then, but it was about 75%. You know, today it's 95 plus. So it's 20% lower, whether that's attributable to the different sentencing system. But that, you know, it was significantly lower. And one of the things I learned in the research was everyone said, well, and I think the prediction came true. Once you shift to determinate sentencing, everything's going to be guilty pleas because everything's going to be set in stone, and there isn't going to be all this uncertainty. So I think it probably would affect the guilty plea rate, and I think most people would probably view that as a positive, or many people would view it as a positive thing. But I am proud to share that data with you.
All right. Well, I think this is kind of unformed thought at this point. I think, you know, if we want to explore this further, I think it'd be helpful for staff to try to kind of focus some thinking here. But of the presenters yesterday, I thought that was certainly one of the things that stood out to me as something interesting. And I'd like to think harder about how we could draw some lessons from Utah. The other state that jumped out, of course, was New York, which, according to what we heard yesterday, reduced its jail and prison population by, you know, over 60% over the past decade, which is extraordinary, and maintained or improved public safety over the same period of time, which is just really, again, in the heartland of what, you know, I hope to accomplish with this committee, improving public safety and reducing unnecessary incarceration. Now, the trick is, at least what the witness described as being the real driver of all that was not any statutory change at all, but instead a change in prosecutorial practice, particularly in New York City, and the roles of alternatives to incarceration. And it was difficult. You know, we've also had prior, you know, meetings on alternatives to incarceration, lack of resources, lack of programs that are alternatives, even in the counties that want to embrace it. So I was curious about what people thought about this, what we might be able to learn from New York. Of course, New York is a giant state, just like New York and just like California, and perhaps deserving of its own, you know, further, even more experts, further research. I mean, you could imagine the reentry services that we described playing a role here. That's our next panel. The financial incentives that we talked about earlier could play a role here. Anyway, I was really struck by the apparent success in New York, and I was wondering if others were as well, and ways that we might be able to learn from that.
Well, I'll just say that having watched the conversation very closely in Los Angeles around reducing the county jail population, maintaining the current low rate, and eventually closing Men's Central Jail, I'd be fascinated to hear how they actually accomplished what they accomplished in New York, particularly in terms of alternatives to incarceration at the time of sentencing, and what that really looked like. Because those I agree with you, those numbers are unbelievable.
Yeah, just to reiterate, and of course in Los Angeles, you know, they have a situation. I think New York City is a bigger percentage of New York State's population than Los Angeles is to California, but still we have a very eager or very, I think, interested district attorney in Los Angeles County. But they reduced New York City's jail population by 2/3.
Yeah,
that's a lot.
Right. It seemed like they had a lot of NGO assistance. I mean, it seemed really extraordinary that there was really kind of a conglomeration of organizations that were in support of this, and they got buy-in from the DA.
That's the critical thing. Even if there was infinite resources in LA, I think today we would be hard pressed to say like, oh, sure, LA would, judges would reduce the number of jail sentences by 60%, or even with infinite resources. So
how long a period of time? Over what period of time?
10, I think it was about 10 years. Is that right, Tom?
And the prison population actually peaked in 1999, so it's gone down since then, which is extraordinary on its own, because I think that's before this conversation about mass incarceration really was happening on the level that it is now. I don't know about the jail population. I think that is more recent, and they're even similar to what you're talking about, Judge Espinoza. They're talking about closing down Rikers Island, which is the big New York City jail, as we know. And it's just New York City is so interesting because there's 5 DAs for that city. So it's the inverse of LA in a way, where you have such a huge county with such disparity or heterogeneity in it. But there is a lot more we could learn here. The person who's now in charge of Rikers Island, Vinny Schiraldi, we're going to speak to him, and we've spoken to folks around the New York State Sentencing Commission. It's a very rich topic, and their neighbors in New Jersey have also reduced their incarceration a lot. Sort of New York, New Jersey, and California are the places that have reduced their prison population the most, and I think there is a lot potentially for the committee to learn from those experiences.
And yes, it's great. We did reduce the prison population, but we haven't reduced the jail population much. So it's sort of,
right.
We got it all up. But I'm really curious as to the amount of resources they put towards it. And I don't mean like, it could have cost less than jailing, but still, how much money did they direct? I was kind of, I know that New York's tax structure is actually more robust than California's, even though a lot of people say California has these high taxes. However, New York collects more
city tax. I can tell you from experience.
And corporate income tax, variety of things. But anyway, I was, the city's rich, but I was blown away. The city's budget was about half of this whole state of California's budget. The budget they adopted, the total dollar amount for just the city, was about half of what the total dollar amount is of the state of California's budget.
Oh.
Yeah. So
I agree. So I mean, I think again, what exactly we might be able to adopt, but there seems to be great success. I was particularly impressed and interested in that this wasn't just a reduction of like marijuana, convictions. She talked about that gun.
Right.
Gun cases were particularly an area of alternatives to incarceration for gun cases, which are a huge contributor of imprisonment in California. New York State and New York City in particular have very strict gun laws, a lot of concerns about guns. Despite all that, alternatives to incarceration for gun crimes were attributed for a large percentage or a significant percentage of this success.
And it seemed like, she kind of, she didn't imply, she explicitly said the judges were ignoring the law, in terms of mass sentencing. I thought New York was the creator of, have a gun, go to prison, 10 years.
No, I think that's right. Well, I think that Ms. Rahman, I'm not sure if I'm pronouncing her name correctly, was saying, just like collaborative courts work here that kind of ignore laws, right? That the judge, that the prosecutors would dismiss charges if somebody participated in one of these programs.
Yeah.
So I don't think that's ignoring the law. That's just using prosecutorial discretion. But again, especially, gun crimes and whether or not we consider those violent crimes, but again, more than just, marijuana offenses or whatever this. And another thing that I think that we should probably think about and consider, and as probably impacted New York's experience, is it's the big shift in policing regarding stop and frisk, and that role that may or may not have resulted in change the jail population. And, that was a really tectonic change in policing in New York City. Well, regardless, Ms. Rahman, I thought was terrific, but of course, it's just to her. And I think that there's probably, some lessons to be learned from New York's experience. So I would propose that we try to pick off a couple of them and hear some more ideas, or if staff present a couple of ideas from New York that seem particularly applicable or realistic for something that California might be able to adopt. Unfortunately, it seems, if Mr. Rahman is correct, this is really driven almost entirely by prosecutorial discretion. That becomes a little bit more tricky for a statutory fix, but something for us to think about. Other people have thoughts? All right. Were any of the other states or anything the other folks said particularly interesting? Otherwise, I'm going to move to the final panel. All right. So the final panel is about reentry and reentry programs. We heard from a couple different models. Susan Burton, who runs A New Way of Life in Los Angeles, Doug Bond, who runs Amity Foundation and STOP programs for parole, and also Matt Kate, I thought, who gave a really interesting perspective as the former head of the prison system under Arnold Schwarzenegger, who really just was fully advocating for reentry programs as alternatives to incarceration, and saying that that prisons were not designed for this purpose, particularly for women. But I did want to emphasize one point that I think is important. We can talk about this. There's reentry. So after you serve your prison sentence, what are the reentry opportunities and how might we be able to improve those? But what we also heard about was, again, for lack of a better term, halfway houses or residential reentry centers as an alternative to incarceration, right? For the last up to 2 years of your sentence. No other state, as far as I know, has that type of program, meaning that the final portion of your sentence is actually served in a halfway house in the community, with the exception, oddly, of the federal sentencing system. In federal prison, you spend your last year or so in a federal, I think they call them RRC, Residential Reentry Center. So I think that, and then there was this, and I think that we should distribute this, a Stanford report that was commissioned by CDCR that showed, and this was just released this week, a dramatic reduction in recidivism for people who participated in these programs compared to control groups. This was a relatively rigorous study that was not just people who self-selected into a reentry program, but there was a control group to it. And in any event, I would strongly encourage us to think about residential reentry as an alternative to final years of incarceration. And I guess I want to open it up for discussion. Judge Espinoza.
I was just going to say that I've toured the Amity Foundation's facility in LA, CDCR facility, and we met with prisoners in the process, and it was very impressive. It was just very impressive. First, it was very much a residential setting. It felt comfortable, felt family oriented, even though it wasn't. And the services that folks were receiving both in the facility and outside in the community when they left the facility on passes, you could tell was making a difference in the lives of people who were going through the program at the time. The way they viewed themselves, the way they viewed their prospects or staying out of custody going forward. So I think it's worth looking at.
I will second that. We send a lot of our clients to Amity, and I've been there several times. It's really an extraordinary place. Another big famous example of a similar type of program is Delancey Street in San Francisco. where again, they are alternatives to incarceration. So this is not just post-incarceration. And their success rates, just in terms of public safety, forget about reducing incarceration, which is a priority to me, but seem, very, very strong. To the extent that we care about finances also, it sounded like that they were significantly less expensive than prison and jails. Anyway, those are some thoughts. Laura, I see you have a question, and then Professor Ochen.
I was just going to say that, as many of you know, I worked in the federal system for many years before coming to Stanford. I was a federal public defender, and it was just par for the course that every client, or almost every client, goes into a halfway house after their prison term before entering the community. It's just much more normal there, and I saw firsthand how it really helped my clients readjust after being in prison. I think one thing we want to think about is, who is running the programs and what kind of programs they are, because, programs that are more like prisons, it's harder than to adjust to regular life. Whereas, programs like Amnesty and A New Way of Life, which, focus on dignity and focus on normative experiences that are not feeling incarceral, I think those are probably more successful in helping people transition to, life on the outside of prison.
Yeah, I agree. Professor Ochen, and then Judge Espinoza.
Yeah, so a couple of things I wanted to lift up that came up during the conversation yesterday. One was the dearth of spaces available for women and their children. And I think that that's something that Susan highlighted. I think the other panelists agreed. I'm not, so some of the comments I'm making, I'm not sure are relevant to, our charge regarding the penal code. But I do think this is something that we should at least raise in terms of, equity and making sure that resources are available broadly. And also understanding that this isn't just something that impacts individuals, it also impacts families, it impacts communities. And we know that roughly something like 80% of people in women's prisons are parents. And they were primary caretakers. So I think that that's something important for us to note. And there aren't a lot of programs that allow women to live with their children. And I think that's important for us to think about. The other is the kind of thing that Laura was just mentioning, which is the conditions of supervision, both on the parole side and on the programming side, in terms of halfway houses or sober living homes or wherever people are paroled to. They can often be very punitive. The conditions can be disruptive to folks reintegrating into society. As I mentioned yesterday, I interviewed a number of women who couldn't keep stable jobs, couldn't keep stable housing because of the frequent compliance checks, because they had to get approval in terms of where they live. LA County, for example, has mobile units that go to Skid Row to do compliance checks because so many clients have difficulty with housing. So I think that speaks to something that does fall within our purview, which is conditions of parole, conditions of release, contracting requirements that CDCR imposes, which Susan referenced as a reason why she opted out of being a contracted facility. I believe that Mr. Cate also mentioned some issues with regard, and this is not with regard to the penal code, but I think it's ancillary, which is zoning and NIMBYism, which prevents build out of these kinds of programs and facilities. So I think that's another sort of maybe incentive that the state can provide to counties and local governments to develop these kinds of housing projects, because as much as we talk about the relationship between homelessness and incarceration, we talk about it as though, being unhoused leads to incarceration, when often it's the reverse, that incarceration leads to houselessness. And so we need to be attentive to that. And then lastly, I mentioned this, but I think it's something that we should discuss, which is the role of private prison operators and for-profit entities in this space. There have been numerous reports about private prison companies operating probation, parole, and the perverse incentives that it creates for them to keep people in those programs, because that's how they get profit for their shareholders. And I worry about that with regard to places like, I don't mean to pick on Geo Group, but Geo Group, right? They are very active in this space. They have they have directed a lot of money into this arena because private prisons aren't as lucrative. And so I think as a state and as a committee, we should look into how those contracts are operating to ensure that they are in the public interest and not in the interest of private prison operators.
I agree with a lot of what you said, and I do want to lift up some of the things, but Judge Espinoza?
I'll be quick. When we are having this conversation about this model and bringing people out of the state prison system early to finish their sentences, we need to be looking at county jails. At the same time, because of the realignment population, they are serving unbelievably long sentences in facilities that were never designed to hold people for more than 6 months or a year. So just want to keep that on the radar.
So you read my mind, because that's one of the things I was writing down. But before I do, there's a couple of things that I wanted to reiterate from Professor Ochin. So first of all, I do think that perhaps the committee should look into conditions of parole and probation. I think that's slightly different from what we're talking about as alternatives to incarceration. Right, we're talking about halfway house as alternatives to incarceration, and parole and probation would follow that. So I don't want to I want to just keep the issues distinct, but I think that that's important. And I also agree completely. This is a challenge with a big system about the quality of different programs, right? We worked, helped facilitate reentry for folks who received clemency under the Obama administration. And we visited and went to RRCs, those are the federal residential reentry centers across the country. And some were spectacular, like Amity and A New Way of Life. Some were actually local county jails. One of our reentry coordinators drove up, and just looking at the address, and it was the jail. And you went from federal prison to this county jail as your reentry center, like still living behind bars, but supposed to be going to job interviews and all that kind of business. Obviously, that's not ideal. But the difficulty though is, how do you regulate when you're trying? And this gets to what another thing that Professor Ochin was saying is, right now we have less than 1,500, 1,200 people participating in these programs, yet 60,000, 30,000 people a year. But if you're doing 2 years, that's 60,000 people a year from prison alone. This doesn't get to the point of Judge Espinosa about jail. It's a tremendous scale issue so how do you maintain quality control? And then finally, the private prison issue, totally agree 100%. I take take a bit of a positive attitude that private prison companies are looking to this space, in that they believe that there's going to be more reentry opportunities. And perhaps that's a good thing rather than incarceration. I mean, maybe that's not the right way of looking at it, but I do agree that the California should really lead the way in ensuring that anything that's funded by the state in terms of incarceration or supervision should really not be in private companies' hands. All right. With that said, let me move quickly to what Judge Espinosa said, and something that I've been thinking about. All right. So the current MCRP model is somebody up to 2 years of incarceration. I'm wondering what people think about, well, if you're sentenced to jail, let's say for 1 year, why not your whole time be in the MCR, the Amity program. It seems the evidence shows certainly that people do better with a longer period of time at Amity. And if you're going to give a portion, of a jail sentence, if you're sentenced to 6 months, but you're going to do the last month at Amity, that just seems like window dressing versus, and maybe this is a way that we get to alternatives to incarceration, right? That, hey, you get a jail sentence for 6 months or less you go to Amity. You don't spend time behind bars. Those are some thoughts. Sorry, Senator Skinner, Professor Ochin had her hand up, and then we'll get to you. Professor Ochin.
Yeah, so I just wanted to lift up something. I think you were kind of trailing off when you said nonviolent, folks. And, I got this sense, and this is not a space that I'm particularly well versed on, but I also think that I got the sense that there were more limited opportunities for people to participate in alternatives to incarceration, particularly not the early release, but a different kind of setting if they have violent offenses. And I don't know that that's right. So I guess I'm asking, is that correct? Did I hear that correctly, or did I imagine that? And if so, is that something we should be thinking about?
So the reason why I said nonviolent was because anybody who's sentenced to 6 months in jail has probably committed a nonviolent crime. So that's why I said that. With regard to the current MCRP programs, because there are so limited, there are some restrictions of people but I do believe that if you're convicted of a violent crime, you are eligible for MCRP. It's just there's some sex offenses that are excluded, or if you have high risks. But in any event, there's some capacity problems. Like I said, it could only house 1,200 out of 30,000 people who are being released. So, you got to start somewhere. But violence is not per se an exclusion from the current MCRP program. Senator Skinner.
What I was going to raise is, I think it would be worth it to have a session on the federal model, because it's possible that we could get some appetite. Again, I don't know, within California, within either CDCR or the legislature for that model. Because one of the issues we have is when we hold a person either in jail or in prison, and we cannot put them on Medi-Cal, for example. We have to cover all costs. And part of the thinking on like medical parole, for example, was that if we did that, then of course we can have the person in a hospice, for example, that is not a prison held hospice, that where then the healthcare costs can be covered by Medicaid. So there may be some, There may be some attraction to it from just a cost point of view, as well as the public safety point of view in terms of that transition. And there may be more support to give the funding, because now I have to fight really hard for the reentry monies that I get. I find it's considered a huge victory when I'm able to secure like 25 million, for example, for Amity and others, this one fund to do the reentry support. And when you think about how many people we release every year from both the jails and the prisons, and that I have to fight that hard for that level of funding when we are spending now over 90,000 per person in the state prison. And I don't know what the cost is of jail less, but anyway, and yet it's very hard for me because that's looked at as, whatever, like a little add-on. Whereas if it were the halfway house, the transition out of the prison, there may be more willingness to fund it. I don't know yet, but it would be worth it for us to explore more.
I've heard extraordinary support for the MCRP program. It's just small. Professor Ochin?
Yeah, I just had a question for staff about a program that I had heard about, and I just Googled it, called the Community Prisoner Mother Program, and how that operates. So it's a program where women can go get substance abuse treatment for non-serious, non-violent female offenders, where they can reside with their children, and it's a part of their prison term, I believe. And so I'm just wondering how that program is operating, what its capacity is, and if it's effective. Perhaps that could be something that should be expanded, especially as many of the folks who spoke yesterday talked about, California over-incarcerates generally, but especially over-incarcerates women. So, especially since our women's population is much, much smaller than the men's population, perhaps that's an area that can be expanded without, a huge impact on the state budget in the ways that expanding it for the men's population would. I'm not saying we shouldn't, but I'm just saying it's a place to start. That might be one place to look at.
We had a program just, and we may have to get some lawyers to help us think this through. We had a program for a while where we had the incarcerated women with children or pregnant in a separate, not in the facility. We were sued because it was unequal treatment, because we didn't have such a program for men, and we had to shut it down. So they're all back in. And the terrible thing is that our women's prisons are even more crowded than our women's prisons because there's fewer of them.
Than the men's prisons.
Yeah.
Yeah.
Senator, I think I visited that pilot program at the
It was
Chino
great.
prison for women. They
Yes.
had maybe 15 or 20 women, and they had their kids in there.
Yes, it was great. But
Yeah, it's about 10 years ago, at least.
yeah.
And I think in other systems, they focus on primary caretakers, primary caregivers for small children, which disproportionately are women, to get around, sorry, I'm getting all these phone calls, to get around that issue.
Well, we do have a diversion court for that, and we now have a law where that can be factored. It was my law, where if you're the primary caretaker, that could be used as by the judge as a reason not to incarcerate you, but instead to do diversion. I don't know how much it's been applied yet, but it is in statute now.
That would be interesting to do some research on. I will also say it's my understanding that the MCRP program, which is the male program, grew out of, I think that the original program was a women's reentry program. So, as you're saying, Professor Ochin, sometimes those can be models for the rest. And I don't know, Tom and/or Laura, are you familiar with the specific program that Professor Ochin brought up? Is that a California program, or is that just somewhere? It is a California program.
I'm not familiar with it personally, but just speaking for someone who's had, many female clients in the past, who are the primary caregiver. I mean, it's a huge loss for the children, and to not have that primary caregiver for many years while their parent is in custody. And so to any extent where, the mother or the custodial parent could be in prison with their child, assuming it's a safe environment for the child and things like that are taken into consideration, that sounds like a fantastic program, and I'd love to look into it.
I just sent you the link to the CDCR page where it's described.
Fantastic, thanks.
And hopefully we would get support for something like this from Kathy Allison, who is the head of the system itself.
You should also note, sorry, I just want to also note, just as a point of comparison, I believe Bedford Hills had a similar kind of a program for a long time. I don't know that it's still operating, but and Indiana has a similar program. So there are these kinds of models across the country. They're not without their detractors, because the argument is they're still prison-like, and you can use the relationship between the parent and the child to gain compliance or in ways that are coercive, but they exist. So I just want to note that it's not just California, they exist in other parts of the country.
Great, we'll look into it.
All right. That brings us to the end of what we heard yesterday. Are there any other topics that folks would like to raise that either came up yesterday during the conversation or from the staff memo? Obviously, this is not the end of the conversation, but there anything that people want to bring up? Senator Skinner.
This is a bit different, but we heard yesterday about the Prop 57, though I didn't hear it, but on the 57 parole, we also heard still that the parole rates are low. So I would be interested in having staff, and this is going to take a bit, but there's been in the last, I don't know, I'll say 10 years, for lack of a better, a lot of new statutes for giving more benefit to get to parole, changing sentencing, some judicial discretion. There's been a whole variety of things like that, but we have not ever, we don't have any data on which of them are working or have even been applied. So for example, the one I just described, the statute I carried around allowing judges to factor that the person accused is the primary caregiver in how they approach the sentencing. I have no idea. Has it been used on one person? Has it been used on? So it would be really nice to see what things have been applied and what not, because since we, for example, the 10 recommendations that we made last year were all for statute changes on the assumption that statute changes will result in the change that we are hoping to achieve. And is possible that they don't. So I think it's worth it for us to collect some data on that.
I agree 100%. I think that that's a primary charge of the committee to figure out what works and what doesn't work, particularly with changes and things that we propose. I want to have changes. You're right that the Prop 57 presentation was basically a presentation on how that's being implemented, depending on how you look at it, successfully or not. And I think that we will have a presentation in the not too distant future from our data team in terms of the granularity of the data that we have and the ability that we do have or not to track some of this information. Tom, is there anything more to say on that part before then Professor Ochin?
No, I agree. And that's certainly the center of the discussions we've been having with CPL, is to just understand what is even happening as a first step and where we are. Ms. Schaefer did in her submissions share the grant rates for elderly parole and youth offender parole and things like that. So just the overall grant rates in the last year. So that's information that I hadn't seen before. So I'll make sure to share that with you, Senator Skinner. I know you're particularly interested in that, but it's in her submission that was submitted to the committee. So that's the start of some of that information.
Professor Ochin?
Yeah, I did have one last thing. It's along the lines of what Senator Skinner was just discussing in terms of parole grant rates, both sort of generally as well as Prop 57. One of the things that Ms. Schaefer said yesterday was that the parole board, heavily considers programming in assessing dangerousness, fitness for release and so forth. And she said that, we don't look qualitatively at participation. We look at, did you attend or not? And I just wonder, is that a good proxy, to see if you went to a class or you enrolled in the class and you attended? Does that, is that better than someone who is doing their own work and reading, or, can self-attest to the growth that they have achieved while they're inside? So I think it is an empirical question, right? Does participation, or at least enrollment in a program, suggest better outcomes in terms of recidivism and so forth? So it's a question that I have. Is that an appropriate consideration? How much weight should the parole board be given? And the availability of the kinds of programs that the parole board is looking to. I don't know if they give more weight to people with longer sentences or shorter sentences. Are they oversubscribed? Are they undersubscribed? Does everyone have access to them? If the parole board is looking so heavily to them, it seems to be unjust to suggest we're going to look heavily to them, but not everyone has access to them. So you're disadvantaged structurally in the parole process because of something that's beyond your control.
So I agree completely with everything. And, this gets back to our original conversation about parole standard and grant rates. Just to clarify, I think that she was saying that just the participation data is used in the paper review process of the Prop 57. And when you have a full board hearing, then you can, if you have, some more of a qualitative assessment of people's participation in programming. I also think, and perhaps we can dig it up, it shouldn't be too hard. There was a recent study by the state auditor about the efficacy of of prison programming. And I think that it was not as successful as people had hoped. Senator Skinner, it seems like you had a reaction to that.
The auditor didn't, in my opinion, the auditor didn't use it's hard to, I'm sure there's some very legitimate things that came out in that audit, but when you start with what they used as their basis for assessing, that was the part that was very uneven and perhaps questionable. So that was the difficulty for me for that particular report. It didn't give a lot of useful information.
Chalk that up to me being with a little bit of information being dangerous. But in any event, let's look at that auditor report and maybe send it also to our folks, to our friends at CPL, and for their assessment about it. But in any event, for better or worse, mere participation in programming at least the conclusion of that report was that it was not a very strong indicator of recidivism. All right. With all that being said, I think that we have some pretty we've given our, as usual, staff a lot of work ahead. I'm going to just run, unless there's anything that people want to add, I was just going to run through sort of the checklist of things that I've been taking notes during this meeting as the things that we really want to focus on as we do staff research moving forward. Again, the idea here is that staff will continue to focus our thinking. This is not any recommendation at all by the committee whatsoever, so that we can, as the year progresses, narrow our thinking towards a set of proposals that we'll make at the end of the year that we think are our top priorities. Not saying that good or bad or whatnot, but just to try to get a list of priorities. So here we go. From what today seems, again, this is the role of parole standards, biases, effectiveness of programming, both in the Prop 57 and the life or parole context. I'm just going to throw in something that we didn't mention that I was really struck by, was that there is a standard that I think is vague and difficult to follow for ordinary life or parole that we talked about in our last report, and that there's a differently worded but also vague standard for parole in the Prop 57 context. I'm struck that that BPH decided to go with a different standard, but offered no more clarity to the first standard, or at least in my opinion. So I'd like to look into that. We talked about appellate review of sentences, in particular in New York, financial incentives for particularly reducing incarceration or uses of alternatives incarceration. We talked about reporting requirements, whether publicly or not, or trying to use our own data in order to get sort of develop a marketplace of what are average sentences. I'm moving quickly here. Expanded use of Prop 57. Then further exploration of successes in New York. And then finally, expanded use of halfway houses. Particularly, I think the focus was as alternatives to incarceration, both for jails and prison, as opposed to reentry programs for post-incarceration, although we did want to talk about and think about parole and probation conditions post-incarceration. Again, to be distinct from as alternatives to incarceration, alternative to last year. And then I think with a special focus on the federal RRC system, which is the last year of incarceration, the federal system. And I think it's extraordinary, honestly, that the federal system, out of 50 plus whatever prison systems that we have in the country, that the federal system is the only one that has a mandated reentry program as part of the last year of incarceration. Okay. Before we move to public comment, is there anything else that the committee members want to add to the list? Staff members, do you have any points of clarification? Anything that you'd like to add before we go on to public comment? All right. As usual, this is an ongoing conversation, right? So this is not something that, ends our conversation on any of these points, but we're trying to narrow and focus our thinking a bit. All right. Now I'd like to move to the public comment period. This is I'm going to read the same instructions that I read every time for those of you who've been here before. To get in line for public comment, please select the raised hand function on Zoom. If you're calling on your telephone, you can hit *9. Please note that the meeting is being recorded and that if you make a public comment, your name and/or phone number may be displayed as part of the recording. If you'd like to make a comment, please select raise hand or dial 9 on your phone now. I'll take a minute to see how many people have make a comment, and based on that, I will decide how long people have to make comments. So, Tom, can you open the
Yep,
the
we've
queue?
got 5 people signed up already.
All right. All right. So I'd like to make we have 5 people, it looks like, who'd like to make public comment. As usual, what's really most effective for us is our written submissions to the committee, especially if you want to make longer points. But in light of the line, I'll ask people to limit their comments to 90 seconds. I really appreciate if you could honor that time limit. And, we do take public comment seriously. And if you need more than 90 seconds to please put your comments in writing. So with that said, Joseph.
Yes.
Joseph, we can't hear you.
Yeah. Can you hear? Okay. I have sent these in writing, but I'll try to pick some of the things from your discussion. I just want to start out with a quote from Susan Burton in discussing the tremendous success as far as recidivism and life success of the residents of her program. She said, "It might look like magic, but it's just care." And I think this is the care that oftentimes is behind people having committed the offenses that they did, their addictions and all the other things, lack of care earlier in their life. And the implication there is that whatever kind of programming and custody or non-custody, the spirit of care has got to be there. Otherwise, you're doing dehab as much as rehab. The financial incentives that was discussed for a while, I think that isn't that one of the reasons that the committee was established? That's the way the financial incentive should be a motivation for digging in and doing this kind of careful study and discussion that you folks are doing. And how do you test for that? Asked Judge Moreno at the beginning. How do you test for somebody's readiness, whether they've aged out or not? We need to have research all along for every process: sentencing, pretrial, release from incarceration, suitability for these MCRP programs, of a study of what are the factors. I believe we will find that people's lives, and then another factor that's been left out, and that is even left out of the algorithms. What's the condition of the community that they grew up in and that they are likely going back to? That is a big determinant, I think, of success. And the community that they're going to and its conditions are a program.
Right.
Let's face that.
I'm sorry to cut you off,
Sure.
Maislish, I think that you're preaching to the choir here in that we all feel that rehabilitation needs to be more at the center of our criminal legal system. And that's one of the reasons why we're so, I hope you heard, enthusiasm for some of those programs, but thank you for your comments. Crispy.
Hi, I'm Crispy, survivor of crime, and I am speaking for Marion Wickard, who is on her way to visit her husband, Tommy, who is at San Quentin Prison, and she hasn't seen him in over a year. Tommy attended his elderly parole board consultation last Friday. And I think this is pertinent to the discussion about parole. The commissioner did not have Tommy's complete C-file, nor correspondence programs Tommy completed during COVID. Many of the CDCR approved self-help groups he attended and completed over these last 2 decades were not in the file. CDCR is being sued for violation under the ADA for not providing the deaf incarcerated the same programs as hearing people. Approximately 2.5 years ago, Tommy was approached by Brantley Choate, Director of Rehabilitative Programs, to work with CDCR as the only incarcerated sign language interpreter, setting up and designing ASL programs in communication for the deaf incarcerated. Tommy has continued his paid job through the past 2.5 years, all during COVID, to help the deaf community. Tommy has received an endorsement for exceptional behavior by an AW signed off by the warden, yet during his consultation, Tommy was informed all his work wasn't marketable. He needs to enroll in vocational courses as his ASL work, well, basically it doesn't matter. If Tommy quits, CDCR loses. ASL interpreters are marketable. Tommy is valuable. And to quote Susan Burton yesterday, everyone has value and would support everyone will succeed. Thank you very much. And I appreciate all the work you do.
Thank you, Crispy. And thank you for being a loyal participant in these programs and in the committee's work. We really appreciate your comments. I'm Miguel Quezada. Am I pronouncing your name correctly?
Yes. Thank you. Can you hear me?
Yes, we can.
Okay, yeah, that's correct. Yeah, good afternoon. Thank you. And I was incarcerated with Tommy Wickard, so Crispy, I know him personally from being inside with them. So my name is Miguel Quesada. I'm the policy director on common law. I think I want to try to be a little bit more brief to respect the time, but thanking Justice Klein for speaking so powerfully about the parole board's role in making unsupported determinations of dangerousness, and also want to ask this committee to thoughtfully consider how subjective and non-evidence-based factors are used to make these unsupported determinations in the process of the parole board. So parole commissioners often cite lack of insight and remorse in whole or in part as a reason for finding a parole applicant unsuitable. I think this is concerning for my line of work and as somebody that has been there. And it's troubling on multiple levels, including for the reason that there is no legal consensus as to the definition of markers of insight. And the board's own chief psychologist at an executive board meeting in April admitted that these factors do not correlate to risk of violence. So this system forces commissioners to decide if specific words, gestures, and actions align with their own conceptions of remorse, which is a complex and very emotion, as in the human condition. So we definitely don't believe this should be the standard. So I respect the work that this committee is doing. Just encourage you to put forward, robust recommendations that address the concerns that Justice Klein has raised about the parole board. And the parole board should only rely on evidence-based factors when making decisions about parole suitability. And thank you.
Thank you, Mr. Quezada. Quezada, is that how you pronounce it? In any event, we should have mentioned, I was aware of the recent testimony about the lack of insight, and I really appreciate what common law has been doing to bring attention to that. And of course, on common law generally, I personally don't want to speak on behalf of the committee, big fan of what you guys do and the leadership from Keith Watley and Julie Hess and everything that on common law does. So thank you for your time and appreciate your comments. G.
Great job, you got it. So I also want to boost what Crispy was saying and support Tommy in any way possible. And I also just want to thank all of you so much. I just appreciate these meetings and what you all are doing to help end the death penalty, and also hopefully your work with LWOP. And I wonder, are there going to be any panels on solitary confinement and maybe emulating the Halt Solitary effort in New York State? And I don't need to go on for the full 90 seconds for once in my life.
Thank you, G. We do not currently have plans to discuss solitary confinement, but I personally am very interested in what has gone on in New York with the HALT Act, and I think that you might see some movement on that. The committee does not currently have that on our agenda, but certainly something that we could consider. So thank you for raising that up for us. And last but not least, Donna.
Hi, nice to be here. Again, I have a son on death row who's factually innocent, but I'm so involved with these hearings that you're doing because I'm hoping that the death penalty will be overturned and we will drop LWOP. So therefore, it might be some place in all of that you're talking about that I'll be pushing something one of these days. I have helped 6 different people through their parole process. 2 of them, it took many years to get through, others was shorter. It is a process, and having some legal help with that would be helpful to them. For those of us who are common people, we struggle to help them do that. I think the judges have a good point of visiting the prisons and knowing what programs are at those prisons so they can direct people when they're sentencing them to the correct program area. It would really be helpful for that. And touring prisons, like showing up with being unannounced and talking to some of the inmates there would be a good thing to do. I really like that idea that they would show up. Modeling after the federal and the European models is a good way to look at it and to cipher out what we need to do here in California, which is a lot. I realize that. And I want to thank you for having these hearings and having the people that you've had come and speak, and you people on this committee putting this together and working so hard. I appreciate that, and thank you. And I'll talk to you next time.
Donna, thank you very much for the encouragement, and we appreciate again our regular listeners. Speaking of which, we have one last public comment. Yolanda, nice to see or hear from you again.
Hi, thank you. I just want to say that I want to highlight what was said yesterday, that in 1976, the Dutch has a national prosecutors regulation, and we need to regulate our prosecutors, at least here in California. Prosecutors should be incentivized for state cost savings rather than incentivized for political careers on the length of sentences. And that is the cause for such misuse of their tools, like stacking as many charges as possible from their prosecutorial toolbox. We need to be focusing, we need not be focusing on punishment, but rather healing through restorative justice practices. And then I also want to comment, Mrs. Schaefer stated yesterday that they go back 15 years when they're looking at somebody. I just want to make it very clear, LWOPs didn't have programming 15 years ago. So their file's not going to be up to par. And I also want to reiterate that 40, 50, 60, and 70-year-olds should be able to appeal administratively for a second look because the chances of recidivism is extremely low. And I also want to highlight that the Western Europe has max violent offense at 12 to 15 years. And then when are we going to discuss LWOP second look? And thank you to everyone on this panel and all of your dedication and positive changes that you're making to California. Thank you.
Thank you, Yolanda. So I just want to say a couple of things. First of all, that we did have a long conversation about LWOP at our previous meeting, and we will be discussing it more and hopefully making recommendations on LWOP and then some of the other issues that you touched on as well. So thank you. We do have one last public comment from Jane Courant. Did I pronounce your name correctly?
It's actually Courant, but that's correct.
Courant. All right, thank you.
I want to reiterate everybody's thanks to this great panel. But I also want to point out how much more valuable this panel, this committee would be with an impacted member. You know, you have heard this from us before, but I just urge you to continue to press for an impacted member. Especially yesterday, when Jennifer, can't think of her last name now, the director of probation, made her presentation. It would have been great to have someone like Miguel Quezada there to say, can you define what insight is? Because I as a volunteer at a couple of prisons, and men coming back from their parole hearings, you'd hear that all the time. They didn't think I had insight. Well, how do I show that? And I think, as other of the panelists in earlier meetings testified, the performance of at the parole is so critical that you can somehow convey that. Number two, Senator Skinner referred to the meager reentry funds that the state includes in their budget. Well, I attended a BSCC meeting. I guess that I think they're the ones, the Board of Prisons,
Yep. Community Corrections
Partnership, whoever, yes, the ones that were awarding grants for reentry. And despite the fact that there was overwhelming support for these many wonderful programs, such as the ones that you heard about yesterday, I think something like 80% of that money went to GEO. This is something that really has to be looked into, because anybody I know who has been in a GEO reentry center, we've got one right here in San Francisco, will tell you some of the horror stories of what goes on there. Finally, I just also want to address something Senator Skinner brought up about the fact that so many of these statutes are going to the law, and yet we have no idea what the regulations are.
Right.
And when we know what they are, they very often run counter to the spirit of the statute, because CDCR seems to do whatever they can to undermine what comes into the statute, particularly Prop 57, the statutes that relate to that. We saw the water.
I'm just going to cut you off. I'm just sorry. I'm just trying to be fair to everyone.
Sure,
but I will reiterate some of what you said. First of all, I appreciate very much about having an impacted person on this panel. Obviously, we do not make the selections. It's the governor. But also to the last point that you said about really figuring out what works and what doesn't work, and how certain laws are being implemented in real life. I think that's certainly why we have some practitioners like myself and former judges on this committee, but also why we are so eager in it to really collect the data, because anecdotes are one thing, but really trying to find out what is actually going on in such a big state is such an incredible challenge, and we want to do a better job at it. So with that said, thank you all. Thank you to our committee members, our committee staff, who are unbelievable. The amount of work that's generated by such a small group of people. I don't feel like maybe the public has an idea of just, how few people are really behind the scenes here. So thank you all for your work, and to all of you in the public who are continue to follow our work. And I look forward to seeing you all again soon. Members of the public can contact the committee and make comments through our website. Committee members, I look forward to speaking with you as we push forward. So thank you all, and have a good afternoon and good weekend.